Welcome once again to Lehto's Law. Here's Steve Lehto.
Got kind of a convoluted case here, but it has someone making a strange argument in court, which I always find fascinating. From Courtroom News, and Ryan sent it to me. Andy Monsterud wrote it. Minnesota argues it is not liable for police dog attack. Minnesota argues it is not liable for police dog attack. And the argument they make, like I said, is unusual. So sovereign immunity in this case, involving a car dealership employee bitten by a canine, may hinge on the question of whether the state can be the owner of a dog. So Minnesota's got what they call a dog bite statute. And the dog bite statute specifically places the responsibility for dog bites on the owner of the dog. So the woman who got bitten filed a lawsuit against the state police and the state saying, in essence, your dog bit me. And they're now making the argument that they are not the owner of that dog. And the question then becomes, well, then who is? Is the dog an autonomous being that punches a clock and comes into work? Hey guys, I'm here now. Arf. And then punches out and goes home? Has like a wife and kids? Like what? Minnesota's Court of Appeals delved into the depths of the English language late Thursday morning in evaluating claims brought by a woman bitten by a state trooper's dog, but the dog was a police dog, okay? The woman is an employee at a Chevrolet dealership, and she brought the negligence and strict liability claims against the Minnesota State Patrol in 2019 after she was bitten by a canine while the dealership was servicing a state police vehicle. So on the eve of trial, the agency moved for dismissal of the strict liability claim under a statute governing liability for dog bites, arguing, number one, that it was not properly disclosed and was barred by sovereign immunity, and the judge denied that motion. And then the judge also found that Minnesota legislature had waived immunity in the text of the statute of dog bites, that the Minnesota State Patrol was at the very least aware of the claim. The Minnesota Court of Appeals primarily considered the immunity findings at oral arguments on Thursday, and they're also looking at the Minnesota dog bite statute. Now, the Assistant Attorney General for the state argued that the statute does not make the state liable for MSP dogs. The statute's assignment of liability to the owner, he said, wasn't enough to waive the state's sovereign immunity. The issue has already been decided by this court, he argued, pointing to an unpublished opinion where a prisoner's dog bite claims were dismissed on the basis of sovereign immunity, and the Court of Appeals affirmed the dismissal. Beyond that, though, the attorney said none of the cases they point to cited actually hold for the proposition that the state should be included in the term owner. So he's arguing and saying that's not our dog. We're not the owner of that dog. And so the dog bite statute, I'll read it to you, the pertinent parts, is Minnesota Statute 347.22. It's called damages, owner liable. If a dog, without provocation, attacks or injures any person who is acting peaceably in any place where the person may lawfully be, the owner of the dog is liable. The owner of the dog is liable, not the person who owns the dog. In case you're going to say, Steve, it's a government entity, maybe they're not a person. Doesn't matter. It says the owner of the dog. Okay? So who owns the police dog? Some people would think the police, but I guess, we got to listen to this guy's argument. So he says that does not hold for the proposition that the state should be included in the term owner. He was referencing a portion of the dog bite statute which states that the owner of the dog is liable. So arguing for the plaintiff, an attorney said the phrase, the owner, left the state none of the wiggle room that they're claiming. The owner is a definite and ascertainable person. If you own the dog, you're responsible for the dog and the dog bite. He pointed to a 2005 case in which the Minnesota Supreme Court found that municipal corporations like cities and counties are not entitled to immunity under the dog bite statute. So cities and towns have already been held to be responsible for the dogs they own as police dogs. The attorney says the Supreme Court found that owner includes government-owned dogs. We can talk about the rule of absurdity. The legislature did not intend to create a distinction between dogs owned by the state on the one hand and municipalities on the other hand. And so it would be silly to raise that argument, but it's been raised. So they asked a lot of questions about this, and they grilled the attorney from the state, and the judge questioned whether a decision in the state's favor would render a waiver of the state's immunity nearly impossible without an explicit statement to that effect, to which the AG said that was entirely possible. Intent must be expressed and it must be specific. Even if the legislature opts never to waive the state's immunity, that would be its prerogative. But again, we're arguing about whether or not the state is the owner of the dog. Speaking after the hearing, the attorney for the plaintiff said he's hopeful the panel would remand the case for trial and briefly discuss the notice issue, which both he and the attorney for the state had acknowledged as secondary. And while the plaintiff's initial complaint didn't cite the dog bite statute specifically, the attorneys defending the state had specifically argued against its elements during its answer to the complaint. So apparently they thought that's what was being brought. So it's hard to say, well, we argued against it, but weren't aware of it. Early correspondence and litigation had also seen both parties specifically discussing the statute. So as to the owner question, the plaintiff's attorney said there could be no doubt. It's a definite phrase. It's talking about one person and only one person. Meanwhile, one of the cases cited earlier that was talking about dog bites and so on says, when the challenged conduct is examined in this way, the decisions to deploy the dog and pursue the respondent's husband must be viewed as operational level decisions that are not entitled to statutory immunity. We therefore affirm the district court's determination that the city is not entitled to statutory immunity. So in that case, the prior case, it's been decided, went up on appeal, and the appellate court wrote that the municipality is not immune from lawsuits that result when their dog bites somebody. And the dog, by the way, in that case, is owned by the municipality. Now the assistant AG is saying, well, that might be well and good, but we're the state. And also argues and says, and we're not the owner of that dog. And I've talked before about how you can consider things, and occasionally you ask yourself hypothetical questions, right? So we know the facts of this case. The vehicle gets brought in for service. There's a canine in the vehicle, and somehow that dog bites somebody at the dealership. That person sues the state police, state troopers, the state. I'm not exactly sure how they've couched that, but the point is they filed a lawsuit and said that that's a bad thing for which they should be held liable. And they're saying, well, that's not our dog. Well, number one, if you kidnap that dog or dog-nap that dog, do you think they'd come after you and say, hey, you stole our dog? Or would they say, you stole someone else's dog? And I also have a friend who is a veterinarian who works at a very well-renowned veterinary clinic, and they bring in police dogs there for their veterinarian needs. And I have to guess that the police force that brings in the dogs probably pays those bills, if I had to guess. Do you routinely pay the bills for someone else's dogs? Do you? I bet you don't. So when someone comes into court and makes an absurd argument, sometimes they do it because statutes are written oddly or something. But here it simply says the owner of the dog is liable. The owner of the dog is liable. Who's the owner? It's not that hard to figure out. And so occasionally you will see a judge who's patiently waiting while everybody else is arguing, when there's several judges on the panel. And they go, if you don't own the dog, who does? It's a dumb argument. It's a dumb argument. But sometimes you take any dumb argument you can. I had a law school professor said, you ride any horse going your way. He was an older fellow. But Minnesota argues it's not liable for police dog attack. And one of the arguments they're raising is, it's not our dog. We don't own that dog. So Andy Monserud wrote this for Courtroom News. Ryan sent to me. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Kilometers are shorter than miles. Save gas. Take your next trip in kilometers.